My name is Stephen Peterson.
Attorney Catherine Lacey here, filling in for Paul Fitzgerald, representing Deborah Shackett, County Administrator, and the County Convention for Belknap, and Harry Bean, Chair, is here with me as well.
Okay, so we are here for the hearing on a request for an injunction that Mr. Peterson, I see you standing at Attorney Linden.
Yes, Your Honor. I have a pending motion to intervene as well. I just didn't know how you wanted me to handle that. That's why I'm sitting not at the table yet, because the motion hasn't been ruled on, but I'm happy to do whatever.
So I know that an objection was filed to that. I'm pressed for time, so let me see if I can get to that. I have some preliminary issues about whether this is going to be dismissed, because there is a pending motion to dismiss that wasn't objected to by Mr. Peterson. The objection was due yesterday, but I sort of deferred because I figured you were going to come in and want to address some of the issues. So are you prepared to address the motion to dismiss?
Well, I would say that this was an illegal meeting, and so the action should be declared void, and they should be following the proper procedures. And also, there's a statute 24-9 that says the chair of the committee needs to call an emergency, and the chair, Mike Sylvia, is here today and testify that the chair at that time that he did not call it. So the meeting that they called as an emergency was not valid. And my intent is aligned with Dr. Strain, and he's represented by an attorney, as is the other side, so it would be sensible to join his cause with mine so that I could also benefit from the same representation.
Okay. Okay. Right, and he has his own standalone case that's working its way through.
Your Honor, Dr. Strang has a separate case, but it's against a different part of his case is filed against the Gunstock Area Commission, and the defendant here is obviously somebody different. They both involve a similar issue.
Right.
That's I set out in the motion to intervene.
Right.
Ultimately, the question whether a resignation was tendered and acceptance of a resignation was valid in any way.
Right.
So
it's sort of circling around the same issues, it seems.
they have some of the same facts.
Right. Okay. All right. So, okay. All right. Attorney Lacey.
Thank you, Your Honor. So we would
Have
ask
a seat, Mr. Peterson.
We would ask that the court dismiss the case based on our two motions to dismiss that were properly filed on September 7th and were not objected to by the defendant, neither one in a timely manner. So we would ask the court to move forward by dismissing that. First of all, on Deborah Shackett, she's the county administrator. She did not serve in her own accord. She only issued the notices based on the chair's direction, as she is required to do by statute and her contractual obligations to the county. Furthermore, there is no wrong against Mr. Peterson here. He had actual notice of the meeting, which is evidenced by the fact that he filed his petition the day of the meeting, before the meeting occurred. Notice was provided via Facebook, Laconia Daily Sun, email, NPR covered it, it was on the county website. So even if he's correct, which we would say he's not correct, and that the meeting was not an illegal meeting, but even if he is correct, he wasn't wronged, and he filed this as an individual. So his petition should be dismissed on that basis. He's correct that there is a statute, but there's actually two statutes, as were covered by our motions to dismiss and the county attorney's letter, which was provided as an addendum to our motions to dismiss. So there's 91A, which is the more recent statute that provides for emergency hearings. The older statute, 24-9D, is actually silent on emergency hearings. And so to read those two statutes in accord with one another, we need to assume that the legislation intended for 91A's emergency provisions to set the tone for this meeting. And it was, in fact, an emergency that the county was facing. The county was facing, Gunstock management had all resigned. the city was at risk of breach of contract for Soul Fest, and we needed a quorum to host meetings. So based on those things, the meeting was properly noticed under the emergency statute in provision of 91A, and in addition to that, the meeting was cured, even if it was illegal. Under the case law of Hull v. Grafton County and County of Cheshire versus Keene, even if the meeting was improperly noticed, the actions that took place on the August 1st meeting were ratified at the September 1st meeting. So at this point, Mr. Peterson's petition is moot because he had actual notice, and even if he was correct, the actions were ratified. Thank you.
Okay. Do you want to respond, Mr. Peterson?
Wanted to restate my request that bring in Dr. Strang's attorney to speak more properly to what's going on here.
We would vehemently object to that, Your Honor.
Okay.
May I be heard that?
I'll let you be heard on the intervening part. I mean, I'm not inclined, I'll be honest with you, I'm not inclined to let you intervene in this. It doesn't seem like this case, has a lot of wheels to get going based on the motion to the issues being raised in the motion to dismiss. I do appreciate that Dr. Strang has his own case. Again, if Dr. Strang wants to add another party that's different than the parties he's pursuing in his case, that's certainly an option I'm sure he can, choose to do. But I don't want to sort of bootstrap and have sort of two actions going, at the same time. So go ahead and I'll let you be heard on the motion.
I would just submit, Your Honor, that they're different in this regard. The other case against the Gunstock Area Commission is a declaratory judgment case in which we're asking the court to make a statement detailing the rights and obligations of all the parties to the case. This is a case having to do with the legality of the meeting that was held at which actions were taken relative to my client. That's his interest, that's his Rule 15 interest as set forth in our motion. And I would also submit, and that is a separate issue from the Gunstock Area Commission question. Each of the cases can be answered without answering the question that exists in the other. So as a matter of law, they're independent of each other. They have totally different legal conclusions that are going to be asked to be reached, even if they involve some of the same operative facts. I would also submit, Your Honor, that certainly, Mr. Peterson's here is doing the best he can. I know that, the superior courts have traditionally been taking it easy on pro se litigants, following the rules. If he's a couple days late responding to a motion to dismiss, I would hope that he'd be given an opportunity to do that. Further, if by allowing Dr. Strang to intervene, the court will at least have the benefit of well-focused issues on the legal issues being advanced in the motion to dismiss. In particular, Mr. Peterson made a brief reference to it, but the right-to-know law that allows for emergency meetings requires the meetings to be posted, not because a majority of the delegation wants it, but specifically it's 91A:2, Roman 2. An emergency shall mean a situation where immediate undelayed action is deemed to be imperative by the chairman or presiding officer of the public body. The chairman at the time is here, and he didn't make such a declaration of emergency. So for that reason, even under the right-to-know law, which allows 24-hour meetings, the meeting wasn't properly noticed up. So there's legal issues that I think having attorneys on both sides will bring into sharp focus for you. And Dr. Strang continues to have an interest in the outcome of this litigation because his rights were affected by the delegation at the delegation meeting.
Okay, do you want to be heard anymore on the intervention issue, not necessarily the issues of...
No, Your Honor, except to state that we would object to Mr. Peterson seeking to obtain backdoor representation through Dr. Strang at this hearing to argue for his ability to file an objection to the motion to dismiss at this time when the time has clearly passed. Pro se litigants are obliged to follow the same rules of court, which are published online, available at the clerk's office. They are readily available to all constituents of our state, and so we would vehemently object to him having any opportunity to object at this point, as he's failed to do so according to the court rules. We would object also to Dr. Strang's attorney representing Mr. Peterson at this hearing and arguing for him as well.
Okay. You want to be heard, I'll give you the last word, Mr. Peterson. Is there anything else you want to say?
I would say I'm at a loss for words.
Zero loss of words, okay. All right, okay, thank you. Okay, so I think I need to take these issues under advisement. I'm not going to be ruling from the bench, but I will do my best to figure out as soon as possible on the issues. Okay, thank you.
Thank you.
All rise.
Grok TV.